I'm here with Ben Salorio, who's running for Superior Court Judge. He's going to educate us on the court system. For people who may not know, what exactly is the California Superior Court?
So the California Superior Court, Carlos, and to our listeners and viewers out there, on the local level, the Superior Court is where people bring their disputes to the judges of the court for a final determination or a decision on whatever issue they may have. For example, in a family law case, it could be a child custody or child support or a property division situation. So a judge would render a decision based on the evidence and the law. In a civil case, for example, somebody scratched your car, you were in an accident, you're suing them for damages. The judge in that case, in a civil case, would hear the evidence and then either give you a judgment in your favor or some other type of judgment. And in criminal law, of course, a judge would preside over the criminal process from start to finish and ensure that all procedures are followed and that, a jury is impaneled and makes a decision to find somebody guilty or not guilty.
What types of cases does the Superior Court handle?
So the local Superior Court handles all cases involving custody and divorce. That would be family law, adoptions. It handles all criminal cases as well. So anything from simply driving without a license to the most serious murder cases. The court also handles traffic court, and the court also does what's called probate, which is wills, things of that nature. When somebody passes away, you have to put the will into the probate court, and then the court goes through the process of administering the will, hearing if there's any objections to any of the conditions of the will, and then distributing the property according to what the person wanted. And then finally, there is a juvenile division to the court. So the court would handle any matters involving criminal cases with minor children or cases where children are removed from their homes because of neglect or abuse. That's called dependency court. So those are the majority of things that are handled at the local Superior Court level.
How does the Superior Court differ from federal court?
So the federal court is limited by the types of cases it can hear based on the U.S. Constitution. I would say the majority of cases in the country are heard in state courts because state courts have a lot wider jurisdiction to hear cases. Federal court, you can only bring cases there that are authorized under federal law or federal statute. So for example, if you wanted to do an adoption or a divorce, you couldn't go into federal court because the federal courts are not authorized to hear those types of cases. Same with a simple traffic ticket you may get, you go to state court, you don't go to federal court for that. So federal court has a much more limited range of cases that they hear, but the work is still important. But the state court level is the most direct level to the voters, and the court that hears the majority of cases, I think, nationwide.
So you mentioned, when I asked about federal court, you mentioned the Constitution. So
yes.
Something goes to the federal court when there's a violation of the Constitution?
Yes, so it goes to federal court if there's a violation of federal law. Or there's some sort of constitutional violation that went on. Then in that case, the U.S. Attorney's Office would file an indictment and bring federal charges. So let me give you an example of a case that always goes to federal court is cases involving illegal entry into the country. That's a federal statute, that's a federal law. So if somebody enters the country without proper documentation, that would go to federal court. That would not go to state court since that is not a state crime that would give this court jurisdiction.
Okay. Can you walk us through the typical steps of a criminal case from start to finish?
Absolutely. So a criminal case start to finish starts typically with a police encounter. So typically there is a police either responding to a call or maybe a traffic violation, what would happen is the officer would conduct an investigation. If they determine that there's probable cause that a crime occurred, they would arrest the person, bring them to the county jail, get them booked. At that point, the clock starts in terms of getting that person bail and bringing the person before a judge within 48 to 72 hours, so the judge can conduct what's called an arraignment. An arraignment is just a fancy word for a judge telling you, reading to you in writing, it'll be in writing, telling you what crimes you've been accused of committing. That's the first stages of any criminal case. After that stage, there are two types of crimes, Carlos. There's a misdemeanor and a felony. A misdemeanor is a lower level type of crime, driving without a license, petty theft. Those types of cases, usually the judge will either release the person on their word or set an amount of bail where they can bail out. Felony is a much more serious class of crimes. Those are crimes where you could face over a year to life in prison. In that case, a judge would set a higher bail or have the person not released. And at that point, you would set what's called a preliminary hearing if it's a felony.
Okay, yeah. Well, that was the next question.
Okay.
What is the difference between an arraignment, preliminary hearing, and a trial?
Okay.
Right.
So an arraignment is the first step in the process of a
arraignment, not arrangement.
No. It's
arraignment.
Arraignment.
Okay.
Think of raining like it's raining. Arraignment.
Right, arraignment. There you
arraignment.
go. Okay,
so an arraignment is just a fancy word for the proceeding where a judge reads you the formal charges that the local district attorney has filed against you. So you have a right to know what specific crime you're accused of violating and on what date you committed that crime. A preliminary hearing is called the probable cause hearing. That is a hearing that has to happen 10 days after arraignment on a felony. Mm-hmm. At that hearing, the judge wants to hear what evidence the government has showing that you most likely committed the offenses charged. The burden of proof, again, it's just a probable cause type hearing. The burden of proof is lower. So think, for simplistic terms, 50%, 51%. If there's some evidence that you were involved in the crime, the judge would then hold you over, right, for trial. Now, a jury trial is the highest level of proof. It's proof beyond a reasonable doubt. In that case, you would have the right to have 12 people from the community hear the charges against you. The government would have to present evidence showing you're guilty. And then you as a defendant or your defense attorney gets a chance to defend against those charges or provide your explanation as to what really happened. And then the jury decides what to do with you in terms of guilt, not guilty, or sometimes conviction of a lesser crime. So those are kind of the three main stages of a felony case.